Top 10 problematic clauses hiding in severance agreements. One-sided non-disparagement clauses. Many agreements prohibit you from ever saying anything negative about your former employer. The problem? These clauses are often one-sided, meaning the company can still speak freely about you. That imbalance can damage your professional reputation while leaving you powerless to respond. Earned commission forfeiture. Some employers try to cut off commissions you already earned on closed deals, simply because payment hasn't hit your account yet. This is essentially a pay grab, and depending on state law, it could be illegal. Always check that your agreement doesn't make you forfeit money you've rightfully earned. Broad release of claims. A release of claims is standard, but some agreements go too far. They may ask you to waive every possible claim, including ones you don't even know about yet. That could mean giving up the right to pursue valid legal action if you later discover discrimination, unpaid wages, or other violations. Unemployment benefits interference. Hidden language in your agreement could jeopardize your eligibility for unemployment benefits. For example, wording that suggests you resigned voluntarily may allow your employer to contest your claim. Don't let severance pay come at the cost of ongoing support you may need. Confidentiality that silences your story. While it's reasonable to keep company trade secrets confidential, some agreements go much further. They may bar you from even explaining your departure to future employers. That kind of personal gag order makes it nearly impossible to have an honest conversation in interviews. Rehire clawback provisions. Some agreements require you to return all severance pay if you're ever rehired by the company, even years later. Imagine being recruited back into a role, only to owe tens of thousands of dollars the moment you say yes. This clause is both unfair and financially risky. Overly broad non-compete and non-solicitation restrictions. Non-competes and non-solicits are common, but in severance agreements they're often drafted far too broadly. You might find yourself barred from working in an entire industry or forbidden from contacting clients you personally brought to the company. These restrictions can severely limit your career opportunities. Restrictive job search limitations. Some employers sneak in unlawful provisions preventing you from talking to former colleagues or even reaching out to vendors you had professional relationships with. These restrictions can cut off your natural career network, making it harder to find your next opportunity. Vacation PTO forfeiture. In many states, accrued vacation and paid time off are considered earned wages that must be paid out. Yet some severance agreements ask you to waive that payout entirely. Repayment of training or education costs. A clause that requires you to reimburse the company for past training, courses, or certifications, even years later, can be devastating. While repayment might be fair if you leave immediately after the company invests in you, applying it retroactively is nothing more than a financial trap. Subscribe for more employment law tips and countdowns. Need help with your severance agreement? Call us now.